Good afternoon, good afternoon, good afternoon, and welcome to our Know Your Rights virtual seminar. Of course, you guys, some of you who tuned in to our financial seminar that we did a couple months ago, we wanted to kind of keep the trend going with that. So we're jumping into our legal seminar. Of course, we know we always have questions about the law and different aspects of the law. What's right? What's wrong? What can I do? Is this fair? And the different things about that that kind of go within that envelope. But it's great when you can kind of have that access, the direct access with attorneys who are very knowledgeable and capable of answering all questions that you may have. So today I am blessed to be able to bring on both attorneys Antonio Sperling and Sam Wiggins, who I know are very knowledgeable and will really be able to answer pretty much any question that you guys are able to generate. So I am really just here to facilitate those things. So any questions that you all have, please make sure that you guys, any questions that you guys have, please make sure that you shoot them in the chat. And I'll make sure we get them answered because we want to make sure we do a thorough job of getting everything answered and addressed today. So Wow, like I said, to open up, welcome. Thank you guys so much for joining us. And I hope that we do our best to get everything addressed directly. Um, I am bringing on both attorneys. Are you guys with me? Sperling, Antonio Sperling,
Yes,
and
sir.
attorney Sam Wiggins. I am going to turn it over to you all. And like I said, I am just here to generate questions and make sure you know that we get everything answered. So I'll throw it off to you guys.
Good
Yeah,
afternoon.
good afternoon. Well, firstly, I want to thank Pastor George and Judith Matthews, and also thank you to you as well, George Matthews, by participating and giving us this privilege and opportunity to not only engage this particular audience, but to just participate in the opportunity to serve in ministry and to provide some knowledge that we have based on. I've had 20 plus years of practicing law, and I'm sure Attorney Wiggins has had is equal, if not more years of practicing law than I have. So we're delighted to be here today. We're really excited to tackle some questions in the area of wills, trusts, power of attorneys, and the probating of the state. So we're ready to go. What do you think, Sam?
I'm ready to go. I want to thank you all for doing this. This is great because, like I was explaining to you earlier, a lot of things come into our practice that's unexpected, and I had several cases that come in this year that deals with this issue that's basically devastated four types of families, and it's amazing that we as a people don't take care of the business of planning for after our death and what our family is going to do and how to protect our legacies. And this is so important. And I was called Attorney Sperling earlier today and was telling him I had four types of cases that come in that really tugs at your heartstrings as to what you can do and how they're basically are going to devastate families in various ways because they didn't do simple planning beforehand. And I will say that there are not a lot of African American state attorneys that I know of because it's not really practical for us to specialize in that because we don't tend to take care of that business. But there are a lot of things that we can do here now that we can preserve the blessings that God gave us so they won't be taken away from our family and be able to pass on to generation to generation. And I can share that if you like, or we can take questions. But it was just amazing that all of this just happened within these just in March before we got to this point and never had it before. So it's something there that needs to be discussed. I would agree.
If I can ask you guys this, let me just say this to kind of get us going. What, say I'm the novice, what would be my first step to kind of getting things in order? Like where, 'cause I know a lot of times, you know, when we don't know where to start, we just kind of throw the whole thing away.
Mhm.
So, what would be a good starting point for somebody who has no idea? Like, let's say, you know, grandma's getting up there in age, you know, we kind of want to make sure we start getting those things prepared for, you know, when that day comes. What is a good starting point with this?
Sam, I'll let you take that first question.
Oh, let me take it from this standpoint, from the case that came in recently. I got four examples of that. Number one, I'm talking about from a family standpoint. I had a husband and wife that had been together over 40 years, loved his wife, they loved each other, had great family relationship, but they just never got around to sitting down and talking about these matters. He died unexpectedly. And because he was the chief breadwinner in the family, everything in the household was tied up in his account. And what happened was when he died, they had to come to my office in order to get the money to keep the family, to keep the house notes paid and all that stuff going forward. And it cost him a tremendous amount of money to do that. And now all of the assets are subject to creditors because we had to probate the estate. The best thing that I always recommend is sitting down and talking with your family, talking with your spouse and say, where are these accounts? What bank accounts do you have? Am I on this particular bank account? What are we going to do with the house? Make a list of your assets and decide what are we going to do and how are we going to do it. If they would have had that conversation, there was nothing intentional on the part of either spouse. It's just that we never got around to doing it. And these are educated business people, knew about transactions, read contracts, do everyday business, and they just never got around to it. Now the family is devastated because all the assets that they generated over the course of a lifetime together is exposed to creditors because we had to probate the estate. So my best thing to do is sit down with your spouse and your children, tell them what you want done and how we can do it, and then seek out the steps to get it done. The primary thing is to avoid the probate court. And this, as much as you can avoid probate court, and the reason I'm saying avoiding probate court is that if you open up an estate and probate your estate when someone dies, creditors have a right to come in and to attach liens and take part of their assets to get paid from the decedent's estate. We try to avoid that as much as possible. And there are tools that you can do to avoid that because you want to keep as much wealth that you've generated over the course of your lifetime to pass to your kids. That's the very first step I would recommend. What can you do to avoid probate, and where we can go and what you want divided and how you want to divide it amongst your children and your heirs. And specifically, this is something I wrote down. I had a conversation that came in. Whatever you do and decide, I always explain to your heirs why you're doing this. I'm of the belief that whatever you have is yours, and I think, with my family, it doesn't bother me about that. But some relatives, some children may get frustrated and try to understand why baby sister is over dad's estate when they bad with money, or you see. So what I always recommend, explain to your children, explain to your spouse why you want to do it this particular way. I believe, and I'll give you an example. You've got a husband and wife, they have 6 kids, and the oldest child has always been like the second parent in the household because they're 15 years apart, and they get upset because mom and dad made the middle child the executive of the estate. Now you got these 6 kids squabbling because they think someone else should do it and don't understand why mom and dad did it. You don't want that tense. You don't want that energy in at this time in their lives when someone is deceased. So I always say, explain to your children why you're doing this. Why is baby sister getting the living room suit, and why is John Jr. getting the Porsche when you know that we need a car? And believe it or not, it only happens pretty much in large families. You can attest, because if you have a generation where you got one child is 50 years old, one child is 35 years old, and another child is 70. And I mean, maybe about 60 years old, you have that disconnect because they're, the 60-year-old acts like the parent of the 35-year-old, and the 35-year-old say, you're my sibling, I don't have to listen to you. So you already have that kind of, they can swerve his leg. You already have that energy. So now you got the fact the 35-year-old telling the 60-year-old what to do. It makes for headaches. So I always recommend that.
So with that aspect, what type of, I guess this is from a question, what type of fees do you incur in walking in to, like, say I come to see you and I sit down in your office, and hey, we need to get our estate in order, yada, yada, yada. What type of fees do I incur with that? So I know that's also a deterrent for us. We want to know, I got to spend money right now. Why? I don't want to spend this money right now. It's already tight. So,
well, look, I'll jump in here and answer that question. I personally have done wills as inexpensive as $350, and I've done some for $5,000.
Oh, wow.
With trust provisions in them. So it really depends on how much or how complex the asset base is of the person who is the testator. So first thing I want to clarify is fee range. And you'll see, even for boutique firms or even to larger firms, that varies very substantially, because some wills can end up being in 3 pages, some wills could be 40 pages. It just really depends on how many assets they're trying to do generation skipping, or if they're trying to do certain transfers through trust to minors until they attain a certain age. So wills, that's a very good question, but your basic middle of the road expense for a will is going to be under $400 or $500 typically. That's if you have someone who has a very clear path on what they desire to be included in a will, whether they want to leave houses, cars, boats, jewelry, and things of that nature in specific clusters. And what I mean when I say clusters is, if you say, I give all of my worldly goods to X person, well, that's going to be a pretty simple will. But if they want to separate out, like Sam mentioned earlier about dressers and furniture and things of that nature, the kid gets the Porsche, and Sally gets, the dresser, then that will is going to have a longer length, and that requires a lot more time and consultation to break down the details of the desired ambition of the person creating the will. But before we go further in this, I want to make sure we're covering some key terms so everyone has an equal understanding here. A will technically is a written document that is drafted by a testator. It's Testator. That's the person who is actually drafting or preparing a will. You actually do not necessarily need an attorney to draft a will. You can write a will on the back of a piece of paper and have 2 people witness it, and that will suffice as a will if certain understandings are clear in the mind of the testator. For example, the person drafting a will needs to clearly understand the document that they're drafting. Obviously, they need to understand what they are attempting to convey in the document. They need to also have a list of what is being conveyed in the document, if it's houses, cars, et cetera, so forth. And then more importantly, there needs to be 2 witnesses that acknowledge the signature of the testator when they sign it. The witnesses are not required under Alabama law to actually read your will. They can just witness you sign the will. Some wills are self-proving, which means there's a separate affidavit that is attached to the will. But in a given situation, a will is going to have several provisions. Some of those provisions would say in Article 1 whether or not the person creating the will is married, whether or not the person creating the will has children, whether or not the person creating the will is omitting certain assets to be given to certain children. And then most importantly, you'll notice in most wills, it'll state whether or not the person desires for their last funeral expenses to be paid first out of their estate. And then it usually goes into other articles that state that certain properties will be given to certain individuals.
Can I piggyback on that?
Yes.
Okay. I agree exactly what Antonio Sperling was saying, is that it's important to have those mechanisms in place. When people come to me for counseling, the first thing I also try to do is that he's absolutely right. You can have a $5,000 will, you can have a $300. They all do the same things. But depending on what you're trying to accomplish. But what I try to do also is try to see what assets that we can have avoid the probate court. Because like you say, once you do the will and you put it in probate court, it's subject to creditors. So the first thing I try to do is look at the age. If you're in your 70s, the needs that you have different for a will in your 70s may be different when you're in your 20s and 30s. And the reason is because once you probate the will, the next step is once someone dies, you have to probate that will. And I get so many clients that come in that had a will and never probated it. And then it caused a whole nother set of problems and creations because we never go back to take care of the business that good Antonio Sperling has done by preparing the will, but because you think it's cost prohibitive, all of a sudden you have this document that hadn't been executed, hadn't been probated, and you have a whole nother set of issues. And I've been getting a lot of those clients, and it comes to be it's cost prohibitive to try to fix the mess that they made because they've let so much time pass by instead of making a mistake.
That's an excellent point, Sam. Here's a question we'll take under advisement too. Can you take a will that you've drafted online and take it to an attorney to have it recorded. The first part of that question, that's a very good question, that yes, you can do a will online. To have a will recorded is not necessary. Now, I'm saying that having a will recorded during the time of a person's life is not necessary. If the person passes away, then that will would need to be recorded in probate court, to the point of what Attorney Wiggins is saying. The objective is to try to avoid probate if you can, and set up as many transfers of assets at time of death, or put them into a trust that when before you pass away, they would transfer at a specific time or at some triggering event. So it's not required that you record a will per se. If you download it from online, you just need to keep the will in a safe place and make sure that the person you are empowering as the executor, which would be a man, or executrix, which would be a female, make sure that the person that you're empowering, that if in the event of your death, they would know where the will is and they know how to access it. Because in Alabama, if you don't probate a will 5 years after the date of a testator's death, then it's considered null and void. It can be stricken, okay? The next point I wanted to address too, there's a question that was also asked: does a person's name have to appear on a bank account for them to get money out of the bank, or will it be sufficient? The answer to that question, I would think, is yes. Your name would need to be on a bank account in order to get money out of an account after someone passes away who is also a co-owner of that account. Most banks will not allow you to take money out of an account of a deceased unless your name is on it, or unless you actually go and have their estate probated so that those funds can be properly accounted for. I just wanted to tackle a few of those questions, because it's very important we address the questions as they come up, because it's a moving scroll.
Let me go back to the will online. I'm not a big fan of online wills, because every one that I've seen that someone brought into my office was not done correctly. And they paid this money and they want me to, it goes with all documents online. I think that you can get a first year lawyer to be competent to prepare a will. I just never seen one that the person has done correctly as far as that. Let me go back, if I can go back to probate court. I've got to explain it and tie it all up as far as the states. I've had a situation where a husband and wife died. They had 6 kids and they had left the will, but nobody probated it. But all the 6 kids understood that baby sister was going to stay in the house. Baby sister stays in the house about 20 years. Baby sister dies and baby sister or granddaughter lives in the house. Now granddaughter needs to get the roof fixed, but nobody probated the estate. And she's got 30 cousins that also would be entitled to share in the property. So I have to tell them, say, hey, we got to get those 30 cousins to agree to give you the house so we can get the money to fix the roof. How you know it's hard to get 2 people to agree instead of 30 cousins? So now it's cost prohibitive. She can't stay in the house because the house is leaking. 30 cousins, half of them want to give the house to baby sister's daughter, other half wants their money. The house still continue to dilapidate because no one probated the will to give the house to that one sister.
Right, and that really plays right into a question about if a mother wants to leave a house to a grandchild and the mom is Asian, should the mom put the house in the child's name before a nursing home gets involved? And I think the answer to that question should be yes. Medicare and Medicaid has somewhat of a clawback provision that allows them to go back and look at transfers from a parent, if you will, or a person who becomes a Medicaid or Medicare recipient, up to 5 years, I do believe, to where they can vet to see if you've transferred assets out of your name before you find yourself at the doorstep of a nursing home trying to get eligible for Medicare to pay your bills and take care of your final expenses. And I've known Medicare to be very aggressive and go back and try to recover property that has been transferred to someone just to basically qualify to be eligible for Medicaid or Medicare so that they can get those governmental benefits. Because you can't have certain assets in your name. You can't have an asset base of liquidity and cash flow above a certain threshold to qualify for certain governmental benefits when it comes to paying expenses as far as nursing homes or things of that nature and hospital bills.
I'm sorry.
No, you're good, Sam.
What I've done in that situation is that a lot of times when people get up in age, they're very reluctant to add someone to the title. What I've done is I recommend what's called a life estate deed. where basically it's where the grantor gets to keep the property for their life, and they can do whatever they want to it. They can rent it out, turn it into a restaurant or whatever they want to. And then once they die, then their beneficiary is named in the deed. And what it is, it allows an elderly person to realize that they're not giving up their full rights.
Right.
And then, along like Attorney Sperling says, you got a 5-year window. And I did that for my dad because he had several properties. And then you got to know your children when you do that, or the person that you do that, because I tell everyone that does that, I say, hey, if someone comes along and offer you $10 million for that particular house, will your child or will whoever you give it to give that property back to you so you can sell it? So you do lose some ownership, but you also keep the main ownership that it is for yours. So you have to know if you're going to add someone to the deed, if you're going to add someone onto a life estate deed, that you trust them enough to say, hey, if I want to sell this property. And it happened in my particular case. My dad divided his properties up. He named me as a beneficiary in a life estate deed. Someone came and bought his property. I said, Dad, he came to me and said, I want to sell it. I gave it back to him so he could sell it and get the benefits of it.
Right.
If you do that, you lose. If you understand, you are giving up your ownership in that home. And if that beneficiary or if that joint tenant says, no, I want to keep it, you're stuck. So you have to know your children. If you're going to do that, you got to be that they're full of integrity. They're going to do what's right. Right. In the event if you want to get the property back to take care of some other business. But that is an excellent way to avoid going through probate and avoid Medicaid.
Right. Here's a question that we had to come in. I think it's a very good question. And it says, must the will be probated? Ideally, the answer to that is yes, because a will is of no effect if you do not probate the will. We know that also scripturally in Hebrews chapter 9, verse 16, it says, in the case of a will, it is necessary to establish the death of the testator. So under the law, if you have a will, I encourage you to have it probated if in fact you have a will. The next question I thought was a very good question is, what would you say to a family member about getting their estate in order if they're ill, not quite bedridden, but confined to a home for the most part? I think that the key part of that is trying to make sure, as Attorney Wiggins was mentioned earlier, that you sit down with your family and you tell everyone what you're looking to do. And once you've stated what you're desiring to do, preferably you would see or feel the need to engage a professional to go to an attorney's office and have a will drafted and not necessarily rely upon an online service, which is not very personable. But I know many people do that, and that's perfectly fine. But in some cases, as Attorney Wiggins indicated, and as I've also noticed in my practice, those wills are usually terrible because the person doesn't know what to put in the actual will, or they leave things out, and they've not gotten a proper consultation to really vet all of their assets. And it's very important that you do that.
I'm sorry, I didn't mean to cut you off.
You're good.
I would also state that when you have a family member in that situation, I think anybody over 60 should also consider getting a power of attorney.
Right.
Because I have clients that wait until it's too late and they need to handle the affairs of a loved one. And you're talking about a power of attorney, maybe $500, $750 as opposed to $5,000 going to get a conservatorship and guardianship. And then you have to have the court to decide whether that person that you want to be over the estate is qualified. So I always recommend anybody in their 50s, late 50s, 60s, or having medical issues to give a power of attorney. And then that your power of attorney, you can designate someone as an attorney in fact to handle the affairs that you can't handle at that time.
Right.
So I would most definitely consider that if someone's in that situation, because you don't want to come around office and have to get a conservatorship and where it's a $700 fix or a $500 fix as opposed to a $5,000 fix because you waited too late if you want to handle that person's affairs and
that's right,
conduct their business.
Here's a question I thought was awesome as well. It says, which is better, a trust or a will, or do you recommend both? I personally would recommend both. You can have a will with a trust provision in some of the articles within the trust. A trust, by way of simply explaining in layman's terms, is a transfer of a corpus, not a corpse, but a corpus, C-O-R-P-U-S, which is the actual asset, where you transfer it into a trust for the benefit of a beneficiary. So you have three parties. You have in a trust document, you're going to have what they call a trustor, T-R-U-S-T-O-R. You're going to have a trustee, which is the person that's going to be entrusted with the corpus, which is the money, the asset, the real estate, or whomever, or whatever. And then you're going to have the beneficiary. So you can have a will and have a trust provision for minor children. You can have a will and have trust provisions that speak to various sundry desires that you want to leave assets to certain beneficiaries. But I suggest that you have both. I think that a will and a trust are like kissing cousins. You got one, you need the other, especially if you have some substantial assets. The next question I saw I thought was pretty good was, let's see, does a power of attorney become void when a person dies? And the answer to that question is yes. If the person passes away, then the POA is null and void, and you would need to either probate the estate or rely upon life estate deeds, such as those that Attorney Wiggins mentioned earlier. So these are all great questions, and they're pouring in, which is awesome. It was asked also, if you have one child, do you need a will? I suggest yes, because you still have to be mindful of the fact that if you have creditors or certain things you don't want creditors to get their hands on, I've encouraged all of my clients, especially those who are getting up in age, and being that I'm in my 50s, I always say getting up in age is now 85. So when you get up in age, you really need to make sure you have a will in place, just some written document. It's just very, 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 very important. But here's a question, Sam. I'd like you to try to tackle this question if you don't mind. It says, what if I'm the person that has written my will and had it notarized but not probated? Is it legal upon my death?
Let's say, as long as the elements of being of a will is there, you got to probate it. So the will doesn't take effect until someone takes it down who's been named a personal representative and probate the estate. But let me give you a caveat. My entire premise, I'm a big proponent of trying to avoid probate court altogether. There are things that Attorney Spurl and I can look at in your estate to see what we can do to avoid it going to probate. Will is great. Will sets down the parameters of what you want your estate and how you want it done. It cuts down confusion, but also is only as good as the people that probate the estate after you die. So I can have a will, leave everything to one child, but if nobody probates the estate, it's just out there. So I believe that you seek an attorney first and say, what can I avoid going into probate and subject to creditors? And that's the biggest thing that you can do. What can I do now to avoid all of my assets going to Medicaid? Because and once you figure that out, and then what can't be avoided in probate, then we can craft the necessary tools to make sure you're taken care of after death.
Right. That's an awesome point. Here's a question: with a life estate deed, what are tax implications, if any? Typically, you wouldn't have tax implications with the life estate deed in this regard. And Sam, you jump in here and answer this question.
I think the only person that may have implication with the tax, I'm not a tax attorney, but I would, based on my limited tax experience, I would say the person that's the beneficiary may be subject to some sort of tax implications once the property is sold. So basically, you get a life estate deed. I'm the beneficiary. I sell that property for $100,000. In essence, you'd be subject to taxes at that time, and that's what I would think. And I would also encourage you to consult a tax professional because basically, if you get the property once the person dies and the property worth $100,000 and you sell it, there is tax implications of selling some property because you have zero basis in it and you sell it for $100,000. So theoretically you could be taxed on the $100,000 gain that you received from that gift. Right. So I would encourage you to consult a tax attorney. Consult any accountant will tell you the same thing and give you better advice as far as your tax implications.
Here's a question: is an advanced directive suggested for those of advanced age in case of a medical emergency? And I would say, hands down, yes. That's a very good question. It's very straightforward. Another question is posed too. Here's one for you, Sam, to consider. It says, no spouse, no children, but would like to keep the house and the family, nephews and nieces. Should I transfer now since I'm in my 60s to avoid Medicare taking?
I think you got to look at two things. That's a good thing to do. I think you have to look at, number one, who you're going to transfer it to. 60 is young. I'm thinking 75, 60 is young, but and what you have to look at is that if you choose to go that route, if you choose to do a life estate deed or a joint tenant deed, if a purchaser comes along 5 years later and say, look, we're going to give you $20 million for your house, is the person that you added onto your title, or are you going to be in agreement and have understanding? It's a trust situation. So you want to make sure that whoever you give it to, you say, look, I want you to have it, but if some better deal comes along, I need to sell it, or if I want to sell it and move to Florida, I'm gonna need you in agreement with me to give me my house back so I can do that. That's why when you do those type of transactions, yes, you can avoid Medicaid if you do it outside of that outside of that 5-year window. But you got to know the person that you're dealing with, and you don't want to give it to a child as or an if that's belligerent is going to say, look, this is my house. I'm waiting on you to die. I'm gonna keep it. I'm not going to work with you on it. You want to give it to somebody you're going to work with. My dad in my situation, he trusted his sons to do what they're going to do. But we didn't want to get a whooping in our 50s for not doing it. So we agreed to comply with his wishes when someone came along and said, hey, I want to sell the house. I'm still scared of my dad. I'm 56 years old and he's 78. He's still scared of me, so I'm going to do what he say do.
Right.
So you got to make sure you have somebody that you can trust, because you are adding them. If you don't trust them, that's not the tool that I would recommend for you. You got to trust who you're dealing with. But that is a good way to do that. Yes.
That's right. Here's a question. Can a spouse do a will without the consent of a spouse regarding their shared asset? Can a spouse do a will without the consent of a spouse regarding the shared asset?
You can do any kind of will that you want to as far as that. Now, the spouse, just because you're married, they have an elective share, and you can go and have elective shares where you can avoid. In other words, you just can't say, I'm gonna just get rid of my wife and not give her anything out the estate. You can write that will, but the Alabama has a provision in what you call elective share.
That's right.
That's been doing, and I'll give you a little background on it. In the early 30s and 40s, if I got tired of my wife, I would go and sell a house to some third party to take all the money and go away with my new wife. And then all of a sudden, my wife and children are left without a home because they're homestead. And they say, hey, you can't do that. Spouses have interest in each other's property. So you would have what's called an elective share. And that's what you would have. And that depends. And that's something that if that happens, then you get an attorney and they'll file and request your elective share and participate in the estate.
Right. And the way the elective share works is it's usually 1/3 of the entire estate, or half, whichever is less.
Yeah.
That's what our state statute indicates here in Alabama. Here's a question. Can heir property be put into a trust? The answer is yes. If so, please explain the advantages and disadvantages. And I'll kind of tackle this. You can put heir property into a trust. The only problem with heir property is that if you own this property and it's not fee simple, which means it's not in your name only, but it's in the names of other people. So it's just like a pie. If you got 10 slices and you only have 10%, then you're only putting 10% of what you own in a trust. So 90% is controlled by somebody else, and your 10% is of the minority, and it's going to adversely impact what can be done with the other 90, but it limits, based on the trust agreement, and what you own, only what you can control. So those are kind of the advantages and the disadvantages. This other question came in, I thought was pretty good. It says, can heir property be, we already read that. Let's see here. If a person has a will that the spouse didn't know about, and the spouse took over the properties and maybe sold some things and later found out there's a will and it goes to probate, what happens then? And I think Sam addressed that question.
Let me go. It's a little bit. I'm trying to get an understanding. If first of all, Alabama is a notice state. So if the spouse sells a property first before the will is probated, then any bona fide purchaser is going to take precedent over a later probated will, because we're a notice state. Now, it says the spouse took over properties and maybe sold some things. Yeah, and that's pretty much going to happen. It's going to be a notice. We're a notice state. So if the spouse sells some real estate before the will is probated and the spouse had legal authority to sell the property, in other words, he owned fee simple title to the property, he thought he did, we're a notice state. So basically, it's going to be whatever comes first.
Right.
Yeah.
Well, very good. I think we've had a lot of questions come through. We have approximately 10 minutes left in the time we have, 8 to 10 minutes. And so this is going well. Here's a question I saw that came in. Well, allow me to make this statement because we haven't touched on much as far as a power of attorney, which is typically just an entry point of someone expressing interest in having their estate probated or having their estate kind of pulled together, so to speak. A power of attorney is basically a document where you entrust someone else to have authority over certain assets that you own during the course of your life. A power of attorney, you can have a durable power of attorney. There are different types. You can have a limited power of attorney, and you can have a power of attorney that what I'm referring to is springs to life with a triggering event. For example, if a person's in good health today, but they anticipate their health may go into decline with an illness that may be more progressing over time, then that power of attorney can take effect once they are determined to be incompetent. But if and at that time, if they subsequently pass away, then that power of attorney will terminate. I've had people think, and I'm sure you've run into this as well, Sam, they say, well, I had Big Daddy's power of attorney, so I should still be able to do what he told me to do in this power of attorney. Well, that power of attorney is null and void because he passed away. And so I think that's a huge issue. And then it brings to the forefront, I think, not only in estate planning, but succession planning of organizations, of businesses, of law firms, of real estate businesses, of ministries. It's very important to have a succession plan in place, because what good is it to build something and then pass away and then it all falls because there was no succession plan, someone to take the helm of an organization or to take on certain roles. So I think that succession planning is a very big part of estate planning, so that you can preserve the integrity of not only the vision, but the integrity of the jobs of people who work to help build the vision. So succession planning, naming an heir in a succession plan, naming the team that you suggested that the heir work with in a succession plan. Those are all very important things. And we see that thread of David to Solomon in the scriptures. So we know how that reads throughout the Bible, but I think that's a part of it. It's a personal Dear John letter to all of us to know we need succession planning in everything we're building in life before we pass away, that we have a succession plan in place.
I've got a quick little things I want to discuss. Just two more things. I know it's quick. Number one, anybody that has a bank account, a pension, make sure that you have a beneficiary name, because a lot of times we get clients in and there's $1,500 in mom's bank account, but the probate the estate takes more than that to get it. So number one, make sure your bank accounts, your savings accounts, your certificate deposits, your retirement accounts have beneficiaries' name. Number two, if you're living in property you think is heir property, you baby girl and you've been in this house for 20 years, your mom stayed in 20 years, and now if it's heir property, you need to go see an attorney now to see about trying to clear it up, because every generation that dies off, it begins to be more expensive to get the property cleared up. So just because you've been living in this house for the last 10 years, like Attorney Sperling says, you may only own 1/10. And now you're trying to get work done to it, and you've been living in their property because nobody probated the estate. So I would recommend that you immediately see someone about making sure that this heir property is taken care of for that second, third generation of your relatives die off. And then now there's more slices that have been divided amongst those heirs. And I think those are two of the most important things that I would recommend that you do now, as far as making sure that you have those two things looked at, because those can get very expensive and it takes a lot of work to clear things up if you don't, those things you can do now to take care of, minimize the cost in the future.
That's right. Here's a very good question I thought was awesome. What is the difference between a living will and an advanced medical directive? Well, a living will and an advanced medical directive is really just a play on words. It's pretty much the same thing. But a will, as I mentioned earlier, takes effect at the time of a person's death. However, a living will is basically where a person indicates on paper, if I were to fall into a state of incoherency, where I'm not cogent, I'm not competent, I'm not able to make sound decisions, I do or do not desire artificial hydration and support. In other words, if a person were to deteriorate health-wise, before they get into that state, they can already indicate on paper through a living will that these are certain things they do not desire to happen. Okay, and so I think that's very, very important. There's another question here. It says, "Isn't there a document similar to a POA, but it is payable upon death? Is this a document you sign with the bank?" And I think this is referring to basically being a part of an account or an account holder. Attorney Wiggins mentioned that earlier, that if you have family members that have substantial assets, real estate, try to avoid probate as much as you possibly can, but then also make sure you have your name on these various accounts, because if that person passes away who's the primary account holder, it's going to lock up that account where you're not going to be able to access that money unless you probate that estate. But if your name is on the account, then technically you can continue to receive proceeds from that account. Now, I'm saying that with a caveat, because some people have passed away and they'll have children, and they have a will in place, and then, big brother or little sister go in there and start raiding the account, and now all the other siblings don't get a portion of what was actually there, because the sister who was on the account just magically thought the Lord blessed her and everything in the account was for her, and they just took it and ran with it. And so that's never a good outcome. And so I just wanted to make mention of that in that regard. The question was asked also, how long does it take to use a probate estate? Usually between, what are you saying, Sam, between 12 and 24 months in some cases?
Generally, the ones I see, they generally close in 6 months, because they pretty much just transfer title to a property because they left it. So usually, if there are no creditors, the statute says that the creditors have 6 months from when the estate is open to file claims against the estate. Mm-hmm. And
right,
usually about 80% of the time there are no claims. 6-month period is up.
Right. And so I think that's a very, very good point. The question was asked, can a case stay in probate over 20 years? I have heard of estates being probated over a period of 20 years because of either assets continue to pour through the estate, or there are complications where you just cannot close certain estates. Typically, estates you can't close are ones where there are creditors. So I've encouraged people to get out of debt as much as you can, especially the older you get. You should have less debt, not more, because the inevitable, death is bad 1,000, right? So, the last thing you want to do is leave someone in a position where they don't have sufficient monies to pay for, debts of a person who had debts during their lifetime. And this other point I wanted to mention too, I think life insurance trusts are very important. And I'll explain that very quickly. If you have questions about this, please feel free to type those into the comments. You can set up a life insurance trust. So let's say, for example, you set up a George Matthews III life insurance trust, but he wants to leave $500,000 to his daughter, hypothetically, and he can make his trust the beneficiary over the life insurance policy. And then he appoints a trustee, and the money comes in at time of death, and then it's paid out to take care of his daughter per his terms and his wishes, which could extend the next 25 years. When she finishes college, give her X, and when she gets married, give her Y. And when she, has 2 children, give her $5,000 a month for the next 10 years. I mean, you could literally stagger the money to be paid out over a period of time through a life insurance trust. So that's a pretty popular document we've been doing a lot of here in my practice. When people don't have sufficient assets to retire all their debts during their life, they just set up a life insurance trust that's sufficient enough to pay off their house, pay off their car, and then have enough money to leave to certain children. But during the course of their life, they may be in debt all of their life, which I don't suggest that, but that life insurance trust could be a saving grace to address all of those last expenses above and beyond just the burial policy. This question just came in. What's the best advice for individuals who have a will that includes their adult children during and after marriage, and that individual is divorced and remarried? Well, the answer to that would be, I think you have to consider if you want to change anything in that will based on the fact that that child of yours has married or remarried. That's just a question that you have to ask yourself personally, in the sense of what your long-term thoughts are about the new spouse, or who is now influencing them in pillow talk. If you desire to see certain things a certain way, that brings you some concern. What do you think about that, Sam?
Yeah, you're gonna definitely have to change the will. You can either do a codicil, and I'm a big fan of just redoing the will to update it, because you can have a will in your 20s. It can change in your 30s. It can change in your 60s. So it's an ongoing situation based upon how life changes. I mean, when you start out in your 30s, you may have a house in Center Point, but in your 70s, you got a house in Center Point and a beach house in Miami and a condo in Gulf Shores, and you got to account for the new assets and stuff that you may have acquired over the course of your life. So it's a good estate planning is evaluating your assets as you go through life to make sure to see what has changed and what changes in life have occurred and adjust for those and let an attorney adjust for those with the proper legal documents.
Okay, great. I have really and truly enjoyed this segment and looking forward to having everyone back on tomorrow at 12 and then Friday at 12. But before we conclude, here's one more question about what happens when a probate goes beyond the statutory period. And we mentioned that the statutory period to probate a will is 5 years from the day of the person's death, ideally. Because if not, the law will treat it as if the person died without a will. So it's important to have a will probated within 5 years of the date of a person's death. And I think that's all the time we have. Listen, I have truly enjoyed this segment. I truly appreciate George Matthews III and his scholarly participation and involvement in helping field these questions. And Sam, you've always been a gentleman and a scholar, and I'm just delighted to serve on this panel with you. And we look forward to having everyone participate further. And tomorrow at 12 noon, we look forward to it. We want to thank you on behalf of Pastor George and Judith Matthews. We truly, truly love each and every one of you. And shout out to Elder Oscar Matthews, who's behind the scene making all the technical things happen. And Pastor Jay, who's done a wonderful job of always supporting the vision 110%. Just hats off to her and to our illustrious pastor, George Matthews. My name is Antonio Sperlin. It's been a pleasure serving you today. God bless you. We pray you continue to keep walking by faith, and we'll see you back on tomorrow. God bless you.